Springfield Preservation Trust versus Springfield Library and Museum Association.
Thank you. Did you get my message?
Mr. Agnell? Who's going first?
She's got this wrong.
Well,
Mr. Mason.
I know that's Mr. Mason, but,
You do?
okay. Does everybody know that Mr. Mason is going to go first?
He's the appellant. Aren't
Right.
you the
Yes.
appellant?
Yes, we are the appellant and cross appellee.
Okay.
Oh,
But
is
it was
that
our
why
understanding-
we're...
Thank you.
Okay.
Good morning, Mr. Mason.
Good morning, Your Honors. May it please the Court, my name is Mark Mason. I am pleased to appear before you on behalf of the Springfield Library and Museum Association, which I will refer to as the SLMA. I am joined this morning by my brother, John Egan, who represents the Archdiocese of Springfield and who joins me in this appeal. I will be arguing for 10 minutes, and Attorney Egan will take 5 minutes. The case before you presents as a determination whether or not the trial court abused its discretion in deeming invalid that portion of a Springfield City ordinance which excludes our client, the SLMA, and Mr. Egan's client, the Archdiocese, from the historic district of Mattoon Street and Quadrangle, which is located...
How can you have discretion? I mean, if the ordinance is valid, he has no discretion to declare it invalid. And if it's invalid, he has no discretion to declare it valid.
That is precisely one of our points. The issue which is raised by my brothers from the Springfield Preservation Trust is that the ordinance itself is invalid, whereas they maintain it runs afoul of Chapter 40C.
Right.
It is our position that certainly to the extent that the ordinance on its face is valid, to the extent that there is absolutely no legislative history other than the ordinance itself, and in particular view of the fact that it is consistent with the letter and spirit of the Historic District Act, Chapter 40C, that indeed it is valid. You will find replete through the appendices reference to cases which have gone up to the appeals court on the legitimacy of this very ordinance. And in those particular instances, the appeals court indeed found that the ordinance at issue was valid. The case presents...
Did any of those involve what I call a frontal attack, such as we have in this case? Whether the ordinance is valid when looked at frontally in light of the statute?
Yes, indeed. And I would state that Attorney Egan was counsel in those two particular cases that arose from decisions of Justice Cross in the Hampden County Superior Court and then proceeded to the appeals court. And perhaps he'd be best to address your particularized interest relative to those cases. The case before you arises when our client in 1983 purchased a dilapidated home called the Donahue House, which is located just adjacent to the SLMA's premises. And during the course of the 1980s and 1990s, the SLMA sought repeatedly input from the Springfield Historical Commission and indeed the Springfield Law Department, the determination as to whether or not that particular premises fell within the exclusion created in the ordinance.
Before your client bought the house, did the Donahue House fall within the historic district?
Yes, it did.
And then after your client bought it, the contention is by virtue of ownership, it was no longer in the district.
Absolutely. The ordinance at issue creates ownership-based exclusions, and indeed ownership-based exclusions as such are permissible. Witness the Beacon Hill Historic District, which specifically carves out exceptions not just for the Commonwealth, but for various personal private residencies on Myrtle Street. Witness the same...
But wasn't that under a different statute?
That was absolutely under a different statute, but the fact that it was under a state statute as opposed to a municipal ordinance makes no difference. For the legislature grants penultimate deference to either state legislature or municipal ordinance when it comes to...
Mr. Mason, it seems to me that if you're looking at historical preservation, that if you say this building, this building, this building, this building is excluded, It really doesn't matter who owns it. I mean, it's ownership-based, but it's not because Mr. Mason owns it, Mr. Ignal owns it, Mr. Nagel owns it. It's just excluded because for whatever reasons, people don't want to have that included. Those buildings don't have historical value and they don't seek to protect them. That's a little different than saying, any time I've got this incredibly valuable building, but any time the library owns it, then it's outside the district. I mean, what's the precedent for that?
I respect your question. If I might reframe it, does after acquired property fall within the purview of the exemption? And indeed, it does.
No, it's not after acquired property. What's the basis of saying if you happen to own it, not after acquired, at any time, if you happen to own it, then it can be exempted because you own it, regardless of whether it's got a historical character.
One needs to read into the ownership-based exclusion the legitimacy of such ownership within the purview of Chapter 40C, so that, for example, an exclusion for Joe's Liquor Store may not be the same as an exclusion for the Library and Museum Association to the extent that such exclusion is consistent with the purpose of Chapter 40C, which includes promoting the public welfare.
But if we took your logic to its ultimate end, the library and the archdiocese could buy all the buildings, and there'd be no more historical area.
That is absolutely true, and certainly that is one of the quivers in the arsenal of the Preservation Trust. But the fact is that the legislature defers to the municipality and doesn't second-guess its selection of ownership, and to the extent, once again, that the library and museums does perform extraordinary educational functions and other functions that fall within Chapter 40C, as it is broadly interpreted,
Could I ask
they may do so.
Assuming without deciding that it was acceptable to, or permissible to exempt certain properties at the time the ordinance was passed, to exempt, and they simply identified them by ownership, but they decided to exempt those buildings. A major part of the plaintiff's argument seems to be that when applied to after acquired property, you are being allowed to change the size of the district without going through the usual requirements to do so. How do you get around that argument?
Because the properties at issue are deemed not to fall within the historic district and therefore not subject to procedural requirements for reduction in size. Witness the provisions of Chapter 40C, Section 10I, that provide that the Historical Commission is granted any and all other rights which it may have in addition to the powers that are granted under Chapter 40C. Basically, the deference that is granted through municipality is reflected in that very large catch-all of Chapter 40C.
Right, but doesn't the statute itself prescribe certain steps that must be taken if the district is either going to be enlarged, which it would be if the library or the church, transferred property to somebody else, that's going to enlarge the district, or similarly, you've got to go through procedures to shrink the district, and you shrink it here simply by the Archdiocese or the Library Association purchasing property.
And we respect that very important point. There's a distinction to be drawn, however, between the shrinkage of the district and the exclusion of the district for properties, such that the exclusion is not equated with the diminution in the district, which would require the procedure set forth in Chapter 40C. What was contemplated in Chapter 40C in that particular provision was that if you sought to whittle away at the existing district, you needed to comport with certain requirements. Built into the ordinance itself is an exclusion which need not address that particular protocol.
Of course, the irony of this whole thing is that what we have is an ordinance that seems to protect people and not historic places, which undermines the entire purpose of the enabling statute. We have these cases that come up under the Fourth Amendment all the time, where we say that the Fourth Amendment protects people and not places, and now we have a statute, an enabling statute, that seems to protect places, and the city has written in an exemption that affords a protection to people that was never intended by the statute?
Well, Justice Spina, in response to your question, I would point to the purpose set forth under Section 2 of Chapter 40C, which very broadly includes the promotion of educational, cultural, economic, and general welfare through the preservation of places. And indeed, the cases cited in our brief broadly construe public welfare and the general welfare of the public to fall within the penumbra of the activities of the Library and Museum Association.
But doesn't that then become a delegation of the power of the city to the bishop and to the museum association to determine, what is going to be what the parameters and the boundaries of the historical district are?
It reflects the deference that the city council awarded to those two entities in light of their particularized activities that fall within the very broadly based purpose set forth in Section 2. As I stated earlier, this is not a case about an exclusion that's created for Joe's Liquor Store. This is an exclusion that has been created for institutions as venerable as the SLMA as well as the Archdiocese.
One
Mr.
final
Mason?
question.
Go ahead.
Or at least for me. Is it clear that the language of Quadrangle Mattoon Street Historic District, that this language with this exemption was the originally enacted ordinance?
Yes.
Okay, so it was acted as the exemption wasn't added at a later date, for
No.
example? Okay.
Mr. Mason,
Yes.
assuming that we do not agree with you, just assuming for 1 second, I know that's a terrible
I can go
question.
there.
Assuming for purposes of argument, arguendo, and so on and so forth, could you just talk a little bit about relief? The building is gone, correct?
Yes, I'd be happy to address that. I appreciate your raising that. We maintain in our cross appeal as cross appellee
Right.
that the Preservation Trust has waived its argument that it's entitled to hearing relative to damages stemming from the destruction of the Donahue House. In that regard, our brief set forth the various locations in hearing before Justice Wernick and Justice McDonald, wherein the court ratifies that they are simply proceeding on the declaratory relief portion of the opinions. Moreover, the SLMA has been grossly prejudiced by virtue of the Preservation Trust's failure to have appealed from Justice Josephson's award of a preliminary injunction, failure to have sought a stay on the entry of such preliminary injunction, and indeed by its verbal representations as set forth in the Appendix Volume 2, reflecting that it was waiving such appeals and further relief. Therefore, we maintain that there should be no remand of this case to the Superior Court for hearing relative to damages.
Thank you, Mr. Mason.
Thank you very much.
Mr. Egan, he did not eat up any of your time. You had your full allotted time.
Thank you, Madam Chief Justice. May it please the Court, my name is Jack Egan, and in this matter, today I represent the Roman Catholic Bishop of Springfield, which is a corporation sole. My time was, the way Mark and I allocated, was to be devoted to remedy, but I would just like to touch on one issue which was raised in the questions to him, and that's a concern, it seems to me, coming from various members of the Court about an ownership-based exclusion. And I think it's well to remember that this was decided on motions for summary judgment, and I would represent to the Court that when this ordinance was adopted in 1972, that area of the city of Springfield, we certainly could have produced evidence to show, was in terrible disrepair, save for the properties maintained by Springfield Library and Museum Association, by my client, and the Episcopal Cathedral of the Diocese, the Episcopal Diocese of Western Massachusetts.
But you're not arguing, though, that we should view the exemption as simply the ownership as it existed at the time the ordinance was promulgated?
If I get to remedy, I'm arguing that that's something that could have been employed by the trial court. I don't think you need to get to remedy, but I think the trial court's selected remedy was an error, and I think one possibility is to do away with the after-acquired portion.
To read it narrowly.
To read it narrowly.
The properties then owned by
You don't
those
just
two entities.
excise the entire. That's not my position. My position is the entire ordinance has to go.
But the city's I take it the way the city, at least the way the city solicitor responded to the Donahue house, seems to reflect that this was intended to be a floating
I think clearly it
concept.
was intended to be a floating exemption because it was in the nature of a reward to those two landowners who had maintained it subsequent to the creation of the historic district. On the east side of Elliott Street, the Springfield Institution for Savings came in with a huge real estate development called Armory Commons and revitalized that neighborhood. Principally, the areas that were affected were houses on Mattoon Street.
Go ahead, finish.
I'm sorry, on Mattoon Street, which is to the north of our properties, Slam's properties and the properties of the Diocese of Springfield. We're not an archdiocese. Mr. Mason promoted us. That may have financial ramifications for us, Mark, so we're not going to accept it.
Mr. Egan, I take it that part of what the intention here is when you get these historic preservations is areas and particular buildings. Was there any claim that the Donahue building itself had some particular historic?
The Donahue building was a Victorian house that was used by an ophthalmologist, William Donahue, as his office for years. It was conveyed by his brother, Thomas Donahue, who's a lawyer in Springfield, happens now to be, his law firm went out of existence. He happens now to be in our office. And I suppose as a Victorian, it had some appeal, but not like the houses, and I'm sure the preservationists will be upset with me, but not like the houses on Mattoon Street, which were row houses and somewhat different. So it was a commercial activity for years, and then Dr. Donahue couldn't sell it, and I thought he donated. I hear now he sold it to the Library and Museums because he came to us and offered it to us, and it was in such a state of disrepair it would have been more of a burden at that time.
Could you answer Justice Glaney's earlier question to Mr. Mason about had there previously been, as it were, sort of frontal attacks saying you can't do this kind of ownership-based?
I can try and answer it. I've never been able to answer Justice Graney's question.
Well, sure you have. Sure you have.
Just because he tells you you haven't answered his question.
Yeah, that's right.
I mean, if you answer it, we'll raise your firm to an arch firm.
Is that going to cost us money? An additional assessment. I believe it was 74, there was a challenge because what was the mother house of the Sisters of St. Joseph, the diocese was going to take down, and that was located between the bishop's residence and St. Michael's Cathedral. And this same entity, not these same individuals, challenged us. They sought a preliminary injunction enjoining the demolition. We had a hearing in Hamilton County Superior Court in front of Judge Cross. He found the ordinance to be facially valid, denied the preliminary injunction. They took it up to the appeals court. Judge Hale, I think he was then the Chief Justice, Judge Hale, who actually was familiar with the property and described having walked it, and asked me, and I never understood this question, if there were still prostitutes and drugs up there. But he did ask that question. He dismissed because the Preservation Trust had failed to join, I believe, the city and the AG as necessary.
No, I have that. I have our little list.
So that's really not a frontal attack. That
It
went off
was
on
a frontal attack, and we address it in a footnote on our brief and basically say what they're trying to do now, since issue preclusion involves any issue that was or could have been raised.
Oh, I see.
That what they're trying to do now is benefit from their failure to properly bring the case in the first case. Judge McDonald didn't accept that argument.
Well, we can go and look at the...
Can I get to just the issue of remedy? We believe that it's not necessary for this court to get to the issue of remedy because we believe the predicate for the remedy was an incorrect finding by the trial court. But should you get there, we think the remedy is controlled by this court's opinion in Greater Boston Real Estate Board versus the City of Boston, which dealt with a delegation issue or a home rule legislation involving rent control. And in that case, there was a dispute about whether or not the city council in Boston and the mayor had enacted legislation in which the definition of tenant was broader than had been delegated in the home rule legislation. The housing court, this court affirmed, found that it was, and therefore the issue of remedy came up. Now, an important distinction in that case had a severability clause in the municipal ordinance.
Right.
There's no severability clause here. Also, it's interesting to note that the trial judge, Judge McDonald, found that case, I believe it's on page 13 of his memorandum, to be the most similar case to the instant case. Now, this court, in 1999, in the opinion, cited the presumption in favor of severability, but then went on to say, but this rule favoring severability has a corollary. If the court is unable to know whether the legislature would have enacted a particular bill without the unconstitutional provision, it will not sever the unconstitutional provision, but will strike the entire statute. And that's the only remedy, in our view, that could be employed in this case. Because
when you say the entire here, do you mean the Mattoon quadrangle portion?
I do.
Not the entire.
Not every historic district in the city.
So it gets rid of the whole Mattoon Library area historic district.
Well, it sends it, as is noted in this case, it sends it back to the legislative body and the mayor to decide whether or not they want to
create a new one.
And that's because to do what Judge McDonald did is to, by fiat, include under the burden of these regulations parcels of land which we know the city council, by two-thirds vote, and the mayor in Springfield in 1972 decided should not be included.
But we know that they wanted to include all that other land.
Yes, but they are so entwined. I mean, that would leave you to rewrite the boundaries of the district. And at least...
Can we say that, with integrity, that what was intended was to exclude the geographical boundaries of property that were owned by the museum and by the bishop at that point in time?
It's that with integrity that gets me in the question.
I
don't...
Then you've created
I'm kidding when I say
a gigantic hole in the district at that point, haven't you?
Yeah, you have created a hole in the district, and you really don't know what the legislature... You're unable to know what the legislature would have done. Would we be content if you just exempted the properties as they existed as 1972? My client would, because we're not...
Mr. Egan, your client... your client is a corporation.
Whoever it is.
No, but whoever in the corporation is making the decision now. But that may not be the case when
It was a different bishop, but we were involved. I know.
But when the bishopric is thriving again and wants to acquire property and so on and so forth. So don't commit to. You can resolve this case, but
okay.
If somebody comes and says, "Would you like this?" and so on and so forth. In any case, your time is up, Mr. Egan, but thank you.
For those reasons, we would respect, and the reasons advanced in the brief, we would respectfully ask that the court overturn the action of the trial court. Thank you.
Thank you. Mr. Ignal.
Good morning.
Now, the res judicata, I think we can get rid of pretty quickly, because the case that they're relying on is res judicata as to a similar suit where you're missing these people or parties. And in this case, everybody, or at least Judge McDonald...
That's right, Justice Green. So there was no jurisdiction in that case. That was
Correct.
the decision of the appeals court, and therefore it cannot be preclusion, and I think I've made that point clear in our brief. If I could address some of the other small points, I would like to get to the remedy. I don't think the gentleman to my left really do, but I do. But to talk about severability briefly, the point in the Greater Boston case was that the provisions were intertwined. And even though there was a severability clause, the decision was that because all of the ordinance was so intertwined, it all had to go. That's clearly not the case here. And the ordinance minus this invalid exemption is a very fine ordinance, which is just...
Oh, but it's so intertwined. If you think about this for a half a second, if you look at all the other historic districts that are created, none of them have this limitation.
That's correct.
It seems to me apparent on the face that the basis of this particular district included ensuring that these properties were excluded.
Well, that's possible, Judge Cordy. I would say this. The record contains the report of the Historic District Study Committee, and there is actually discussion of this particular matter. And the study committee's first recommendation was a full district with no exemptions. Their two other recommendations were, first, what they called a Mattoon Street Cathedrals District, leaving SLMA out completely and doing it by showing it on the map, which we believe is what Section 3 of the Act calls for. The third option, the least preferred according to the study committee, is what was done.
Study committees are study committees.
I understand that.
The question is you need the votes.
I understand that. And so my point simply is that all of these were on the table and were discussed. And no one can know for sure what would have happened if someone had said, wait a minute, we can't do it this way. I do believe that what the city would have done then, if someone had drawn them to carefully examine the Enabling Act, is what they could do the day after this court upholds Judge McDonald, and that is redraw the lines following the procedures that are mandated by Section 3 and produce a map that shows what is in and what is not in the district.
Couldn't they have done that back then, as opposed to just referencing the two owners? They could have drawn the map to exclude those properties.
They could have, and in fact, to turn to the Beacon Hill case, which my opponents love to rely on for the proposition that what was done in Springfield is appropriate. The Beacon Hill Act is essentially a verbal map, and it describes by reference to the streets what is in the district, and then it goes on to say, except not the lands that are owned by the Commonwealth or the following parcels, and it identifies them not by who owns them, but by their street addresses. And so when you look at that act, you know what's in the district of Beacon Hill and what's not in the district.
Well, what happens in that case when the Commonwealth, what happens in that case when the Commonwealth acquires land?
I believe the wording of that act would be ambiguous. It doesn't, as this ordinance, say however owned or controlled. I think that the plain meaning of the ordinance is, as everyone who has looked at it has declared, that is, it does apply to after acquired property. And I believe that is the most pernicious aspect of it, as this case illustrates, and as some of the questioning.
But that does seem to beg the question as to why wouldn't it be an appropriate remedy to read the exemption narrowly and get rid of after acquired? To say
that would be a possible outcome, Justice Sussman. However, I believe that Section 3 of the Enabling Act calls for a procedure that ought to be followed, and it ought to produce a map, because such a decision would still leave a deceptive map. The map is in the record many times in the appendix, and it shows an historic district known as the Quadrangle Mattoon Historic District. And yet, in fact, the only parcel on the quadrangle that is actually in the district is the Episcopal Church, because the rest of the quadrangle is exempted. It seems to me that one of the values that the state insists on in its Enabling Act is a map. I don't think it's a technicality, as it has been described by my opponent. It is specifically included in Section 3, and in fact, the language, if I could quote it, says that.
But so fine, we can have the remedy be that the exclusion is limited to properties that were owned at the time the ordinance was passed, and there be an order that a map be drawn up now showing them.
That could be done, although, frankly, if Judge McDonald's decision is upheld, it seems to me that what we would next have would be the political process going back and doing it as they should have done it in the first place, and they could redraw the map. But there would be no harm in the meantime, because I don't think either the diocese or SLMA would be prejudiced by, for some limited period of time, being subject to the controls of the district, unless they plan to tear down one of their museums. In the meantime, I don't think that's the case. On the other hand, I think, as questions suggested, if the entire ordinance, and it was one ordinance, so the logic of Mr. Egan would lead not only to the elimination of the Quadrangle Mattoon District, but the other 5 districts as well. It is all one ordinance.
But that's not. But that clearly. I mean, if we apply, there's certainly statutory tools that we could apply to suggest that the others are very much standalone. Clearly, clearly the town wanted to create a series of historic districts. This is the only one in which they detach this limitation.
I understand that, Justice Gordy. So if we simply strike the Mattoon Quadrangle District, the problem is the next day somebody could tear down the middle row house of that long row of houses on Mattoon Street. Because until the city council passed a new ordinance, there would be no historic protection.
But I thought, and that includes, did I misunderstand you saying that the only property that's in the quadrangle but isn't owned by these two appellants is the Episcopal Church?
There are 6 buildings that face the quadrangle. One is the library, whose ownership is itself now a blur, but the other four of the other buildings are owned by the Library and Museums Association. One is owned by the Episcopal Church. The Catholic Diocese lies to the east of the quadrangle. And then to the north, there is Edward Street, where the Donahoe House was, and then Mattoon Street, which on both sides has these old Victorian row houses. So in terms of the quadrangle itself, there are 6 buildings, the Episcopal Church, the library, and 4 museums.
So a sharp developer could come in and buy a bunch of row houses on Mattoon Street and tear them down if there was this hiatus.
That is the danger, Justice Greene, which is why we would urge the court not to strike even.
But if he bought them and didn't have time to tear them down before the new district is reestablished, assuming we go the way they want to go, he'd be stuck with the new district.
That is correct. But it seems to me that the law that is developed on severability, recognizing that it is often difficult to know what legislators would have done in a configuration that they didn't actually consider, that the court has developed a presumption that if the remaining language has independent force, then it should be sustained. And clearly, the language of that part of the ordinance that creates the quadrangle Mattoon district has independent force if the offending exemption is removed. And it is, as I mentioned, the first choice of the study committee.
But isn't that indeed, this independent force doctrine, simply a way of trying to get at legislative intent?
Well, that's how it's articulated, Justice Cordy. I do believe, especially when we're dealing with local towns, boards of selectmen, we could be dealing with town meetings, for that matter. It seems to me the notion of trying to figure out what they would have done is a extremely difficult task, and so I do believe that the independent force is an appropriate way to address the problem that is confronted in these situations, and I want to emphasize the availability of the legislative process to do it again and get it the way it was intended to do, but get it the way that the state mandated. Because I think the central issue in this case, and the heart of Judge McDonald, don't want to promote him. Judge McDonald's decision was that there are important procedural requirements in the Enabling Act that they were not followed, and as questioning in the appellant's argument indicates, the simple transfer, and it was a donation. There was no sale. The deed is in the record as well. Took a property that was protected, and suddenly, as though a trapdoor was opened by a private party, suddenly that property was no longer protected by the historic district. A certificate of non-applicability, which calls for no hearing, was all that it took to authorize the demolition of the building.
Is there some, maybe you don't know this, but is there some reason why the trust did not take an appeal from the demolition?
Well, there's nothing in the record. I think it had to do with finances and questions at the time, which this is before Mr. Nagel and I were involved in the case, as to how strong or weak our position was. But we believe it is a strong position. We believe Judge McDonald got it exactly right in his decision declaring that exemption invalid, and we think you should uphold it, that there's no preclusion. The case is not moot. I mean, I think as I turn to the remedy part of this case, I think it's evident that the fact that the building has been demolished does not moot this case, because it's about more than the Donahoe House. It's about the ongoing threat to the district that would remain if this exemption were not stricken. And so clearly, it seems to me, there is a live controversy. And even if it was only about the Donahoe House, the remedy, we believe, just in terms of the Donahoe House, is something that the Chancellor needs to consider with an appropriate record. And our appeal is essentially one that asks this Court to send the case back to Judge McDonald and direct him to allow a record to be developed so that, in accordance with Sections 12A and 13 of the enabling statute, both of which describe his role as a court sitting in equity with the full range of equitable powers so that he can then exercise his judgment and decide what remedy, if any, is appropriate. And we never waived our right to the remedy. One of the difficulties is that my opponents continue to talk about waiver without ever pointing to language in which we waived our right to further remedy. What we did waive, and I will frankly acknowledge, we waived two claims that were in the original complaint, which we did not view as having merit. One had to do with technical naming of SLMA, and there was an original claim on that ground. We waived that. There was an original claim about constitutionality. We didn't believe that that had anything to it, and we waived that. We never waived, we always alleged and stuck with a claim which Judge McDonald sustained as to liability. But a claim has both liability and remedy. And
But you got your remedy. You got a declaratory judgment.
Well, declaratory judgment sometimes is the only remedy that a party either seeks or that they are entitled to. We don't believe this is such a case. We believe that this is a case where we are entitled, in accordance with sections 12A and 13 of the enabling statute, to present our position with respect to remedies. The statute itself, for example, includes as a possible remedy the reconstruction of the building.
Isn't that a classic case of latches?
Well, it may well be, Justice Spina, that particular remedy would not be chosen by the Chancellor, in part because of the fact that we did not appeal. And I think that the defendants ought to certainly make that point to Judge McDonald, and it may well be that he will not order the remedy of full reconstruction, but that doesn't limit the possible remedies. The Court, according to both of those sections, is sitting in equity, and the language couldn't be broader as to the possible remedies that would be appropriate. And it seems to me at the other end of the continuum, something as simple as a plaque, which we think the defendant should put up at that spot, simply recording the history, which is consistent with the goals of my client to preserve history, ideally by keeping these buildings in shape and protected on into the future. But failing that, there are other ways to preserve history, and those would be among the possible remedies that we should be able to turn to here. But most importantly, I think we need to have a chance to make our case in the trial court, and we were deprived of that by essentially a minute order which Judge McDonald handwrote on our motion saying no further remedy is warranted. This is not a case of an abuse of discretion. This is a case where he never exercised discretion.
But did you ask for reconstruction below?
We asked in our, and this is included in the supplemental appendix, where I have included the memoranda that we submitted to Judge McDonald, and in the motion for partial summary judgment. Sorry, let me. In the motion for partial summary judgment, we made it clear that we were only seeking a determination as to the liability of the defendants, and that it would take a further record before the remedy could be addressed. So we made that clear before he ruled on our motion for partial summary judgment. Following that decision, the defendants appealed, and we sought to prevent that, arguing that the case wasn't over. And the motion was styled as a motion to stay assembly of the record. And Judge McDonald heard argument on that. The memoranda we submitted at that point is also in the supplemental appendix. And in that memoranda, we went further in terms of presenting what we described as some of the evidence.
I see that, but one of the people you have skipped over is Judge Wernick.
Yes.
All right.
Well, Judge Wernick addressed the case after the building had been torn down, and the pleadings were in disarray. Not all the defendants had answered. Judge Wernick said, we need to get the pleadings closed, and I want dispositive motions. And in response to that, we filed a motion for partial summary judgment. It was at that point that Mr. Nagel and I got into the case.
But did you file a motion to amend the complaint to ask for relief in the nature of reconstruction?
No, we did not amend the complaint. The complaint contained a prayer for all such other further relief as is warranted.
But isn't that usually designed to tidy things up as opposed to a major specific request for relief?
Well, I think sometimes that's what's intended. I think, as our brief suggests, under Rule 54C, even if we hadn't pled for this, if we're entitled to it, we should get it. We should get it.
You should get it. If you ask for it, but where you don't ask for it, it seems like you're trying to turn Rule 54C into a permit to blindside people.
Well, I don't think it's blindsiding. We certainly made clear in our papers in connection with the motion for partial summary judgment that we sought further remedies. Without being specific, we were, after all, only litigating the liability issue, and it didn't seem appropriate in connection with asking Judge McDonald to rule on the validity of an exemption to start talking about remedies, except to make clear, as we did, that we were preserving our right to seek remedies. We made that clear in our motion to stay assembly of the record, and in that we have, although it's not, for example, what we would have presented on a motion for summary judgment, there was an offer of proof in that memorandum, which is repeated verbatim in our brief in this court, in which we indicated some of the evidence that we would adduce at the hearing we believed we're entitled to. And essentially that's what we think needs to happen with the cross appeal, is that a record, we need an opportunity to develop a record. The failure to appeal certainly is relevant there, and it may well foreclose the remedy of reconstruction. But there are many other remedies, Justice Spina, which I think we have a right at the first instance to have the chance to take a look at and exercise his discretion, and then if somebody's unhappy, there may be another appeal.
Thank you, Mr. Igman.